Donald Trump just destroyed his own claim of immunity that the right-wing Supreme Court gave him on certain issues by Donald Trump filing a $15 billion lawsuit late Monday night against the New York Times.
Donald Trump just took a legal blowtorch to his own immunity myth and did it to himself. He filed a $15 billion defamation suit against the New York Times personally, and in the process invited the Times lawyers to drag him under oath and rummage through the very closets he spent years padlocking. You want immunity? Don't sue the paper of record over articles and a book that document your scandals, then brag that your brand is worth $100 billion. That's not strategy. That's lighting a match in a fireworks store. If you're here for the short version, Trump the strongman just volunteered to be deposed the defendant, except he's the plaintiff. And when you're the plaintiff, you don't get to cry presidential immunity and run off the field. Legally speaking, he walked into the boxing ring, dropped his helmet, and asked the referee to hold his jaw. Smash the like button so more people see this breakdown, and sub if you want smart receipts with a side of roast. Now let's unpack exactly how this backfires. Big. Late Monday, Trump filed a $15 billion defamation complaint in Florida State Court against the New York Times and 4 of its journalists, Suzanne Craig, Russ Bettner, Peter Baker, and Michael S. Schmidt, claiming a 2024 book and a series of articles before the election harmed his one-of-a-kind brand. The AP obtained and summarized the filing. It targets the Craig Buettner book, Lucky Loser, September 17, 2024, Craig Buettner's pre-publication article, The Star-Making Machine That Created Donald Trump, September 14, 2024, Baker's For Trump, A Lifetime of Scandals, Heads Toward a Moment of Judgment, Okta 20, 2024, and Schmidt's piece on John Kelly's warning that Trump would rule like a dictator, October 26, 2024. 2 key facts up front. He sued in his personal capacity. That means he can't hide the ball behind "I'm the president, I'm immune." He chose the fight. The usual shields don't apply to him as a plaintiff. He made his reputation and business performance the issue. The complaint literally touts his net worth and brand valuation, which opens the door for discovery into his finances, deals, bankruptcy history, and public scandals. The very subjects he says are defamatory. That's called putting something at issue. And courts don't let you brandish that sword while hiding behind a privilege shield.
Late last night that Donald Trump filed this lawsuit against the New York Times. In many ways, it's incomprehensible. I mean, the lawsuit, it's hard not to comprehend at an intellectual level, to literally read it. I'm trying to even understand, what are you alleging? Because the first few paragraphs whine that the New York Times endorsed former Vice President Kamala Harris. And then it starts to talk about a book that was published by New York Times authors in September of 2024, and how there were these articles that were written leading up to the election a year ago, and that this is upsetting Donald Trump today. And he references a September 17, 2024 book that was published called Lucky Loser: How Donald Trump Squandered His Father's Fortune and Created the Illusion of Success, authored by Craig and Buettner, Susan Craig and Ross Buettner, Lucky Loser. Then it says, in the lead up to the publication of the book days earlier, on September 14, 2024, the New York Times published a defamatory, malicious, and false article titled The Star-Making Machine That Created Donald Trump, authored by Craig and Buettner, Susan Craig and Ross Buettner. And you see it right there. Then on October 20th, 2024, the Times published another, this is what's being alleged in the lawsuit, another defamatory, malicious, and false article titled, For Trump, A Lifetime of Scandals, Head Towards a Moment of Judgment. Again, this was authored by Peter Baker on October 20th, 2024. And then it says, in another election interfering salvo, on October 26, 2024, the Times published another false, malicious, and defamatory and disparaging article authored by Michael Schmidt. And it says, as election nears, Kelly warns Trump would rule like a dictator. ... Donald Trump's former chief of staff, a retired 4-star general, John Kelly, said that Donald Trump would rule like a dictator. Seems that was pretty prescient because, in my opinion, that's what Donald Trump is doing right now.
In a world saturated with information, finding the truth requires unwavering dedication and independent voices. America Facticity stands as a beacon for factual, unbiased reporting, delivering the stories that truly matter. Join our membership for just $9 a month. Your support helps us grow our team and create even better content. Find the link in the description below.
Quick refresher on the law he just stepped in. Public figure defamation requires actual malice, knowledge of falsity, or reckless disregard. That bar is Everest level high for plaintiffs like Trump because of New York Times versus Sullivan, describing a lifetime of scandals, or quoting a retired 4-star chief of staff, John Kelly, warning of authoritarian tendencies, is classic protected speech, opinion based on disclosed facts and newsworthy reporting. Opinion and rhetorical hyperbole are not actionable. The court has reiterated that opinions, especially in political debate, get wide latitude. See Milkovich versus Lorraine Journal for the test distinguishing fact from opinion. Florida anti-SLAPP statute lets defendants move fast to strike meritless suits that target speech on public issues and recover fees. Don't be shocked if the Times files an anti-SLAPP motion before lunch. And about that immunity. Last year's Supreme Court ruling carved some immunity for core official acts in criminal cases, but it doesn't give blanket protection for private conduct, and it doesn't let a president who files a private civil suit escape discovery. Clinton versus Jones already told us a sitting president can be deposed in a private civil case over unofficial acts. Trump just volunteered. Again, why this blows back? He opened the discovery floodgates. Because Trump is the plaintiff, the Times now gets to do what it does better than anyone: ask hard questions under oath and demand the documents to back them up. Here's what lands on the table the second the Times answers the complaint: a Trump deposition notice. Clinton versus Jones makes it near impossible for him to duck. He can try to slow roll, but courts don't love plaintiffs who sprint to court and then refuse to play. Financials and tax records to test his brand worth $100 billion claim and alleged damages. He made those claims. Now he has to prove them. Florida's anti-SLAPP also incentivizes the Times to force a quick merits test. All communications and drafts relating to the articles in the book, he says, are false, because the Times will show its sourcing and then flip it. Show us your contrary evidence. That's brutal when the defendant is the paper of record, and the plaintiff's counterproof is vibes, Epstein-adjacent material he himself referenced. The AP notes Trump separately sued the Wall Street Journal in July over a story about a happy 50th note to Jeffrey Epstein, a note later released by Congress that Trump denies signing. Raising it in this new suit invites questions about his relationships, denials, and handwriting analyses, because he put it at issue. Sword, meat shield. Legally, this is the sword and shield problem. You can't use your reputation as a sword for damages and then raise privilege or immunity as a shield to block discovery into that very reputation. Courts routinely call that out. Can he shout executive privilege? He can try. But privilege is qualified and topic-specific, not a magic cloak. When the information goes to the core of a claim he filed, brand value, alleged damages, truth, falsity of statements about his finances or scandals, courts weigh it heavily against secrecy. And remember, the SCOTUS Core Official Act immunity is about criminal exposure for official acts, not blocking civil discovery into unofficial life choices a plaintiff put at issue. Translation: your immunity isn't a get-out-of-deposition free card you can use after you sue somebody.
And then Donald Trump, in this lawsuit that he files, he starts like posting photos of himself at The Apprentice. And he says what a successful business person that he is. And he says that everything he touches is turned to gold. And it has like these weird photos. It's like, look at paragraph 56. Trump has built, transformed, established, and revitalized businesses, projects, and brands, including The Apprentice. And then it lists a bunch of other things. Trump has authored many best-selling books. And it goes, Trump's hundreds of history-making media appearances and roles include WrestleMania, Ghosts Can't Do It, Miss Universe 2001, Days of Our Lives 2005. And then it goes, Trump has utilized his business and real estate acumen to grow his business and holdings across America internationally, including Ireland, Oman, Scotland, Vietnam, and Dubai. As evidenced by the meteoric rise of Truth Social, Trump's business success resonates in the American collective consciousness. And then the rest of this is like showing like Donald Trump's ratings in The Apprentice. And it was like, look at the ratings in The Apprentice during all of these years on page 38. There was another page in this lawsuit where this thing just keeps getting more and more deranged, where it says, Trump has also brought a powerhouse defamation lawsuit against the Wall Street Journal, arising out of a July 17, 2025 article falsely claiming that he authored, drew, and signed a card to wish the late and utterly disgraced Epstein a happy 50th birthday. Okay, so now let's talk about the waiver of absolute immunity. Donald Trump has filed this bizarre and deranged lawsuit for $15 billion against the New York Times in his personal capacity. And how do you know it's in his personal capacity? You go to the party section of the lawsuit, and it talks about who's suing and why are they suing. And then it mentions that the parties are Donald Trump, and it talks about Trump is a citizen of the United States, a resident of the state of Florida, the 45th president. And then it goes, Trump's transcendent ability to define wrongful conventions has been vividly reflected in his successful undertaking to restore the integrity of journalism. But go up right there. It says President Donald J. Trump on the caption, an individual.
The reporting he's attacking is inconveniently real. The book Lucky Loser by Buettner and Craig, NYT journalists, was published September 17, 2024, and traces Trump's finances and image-making machine. That's a fact, not defamation. The articles, Peter Baker's Lifetime of Scandals, ran Oct. 20, 2024. Michael S. Schmidt's piece on Kelly's dictator warning ran Oct. 26, 2024. Again, true that they exist, newsworthy, grounded in on-the-record sources. Trump calling those false today doesn't retro-erase their sourcing. If anything, Discovery lets the Times walk into court with receipts and ask him on camera to dispute specific facts, under penalty of perjury. If he waffles, he loses. If he doubles down, he risks perjury. If he pleads the fifth in a civil case, jurors are allowed to draw adverse inferences. Pick your poison. Roast interlude. Suing the New York Times for calling your life scandal-filled is like suing the Pacific for being wet. You can try, but all you're going to do is make the tide famous. What the Times is likely to do next, they've got 2 clean lanes and can run both. Anti-slap, motion to dismiss. Florida's statute targets suits meant to chill speech on public issues and allows fee shifting. Expect a brisk filing arguing the speech is protected opinion on undeniably public concerns about a public figure, with no plausible actual malice. If granted, Trump risks paying their legal tab. Answer plus, immediate discovery. They can answer or conditionally answer and notice Trump's deposition, subpoena business records, tax returns, and documents about Truth Social stock, licensing deals, loans, valuations, the works. Why? He claims precipitous declines in brand damage. They'll test whether those numbers are real or if, gasp, truthful reporting is just a handy scapegoat for a meme stock's gravity problem. Pro tip for Team Times, schedule the deposition early. Clinton vs. Jones is your friend, and the longer you wait, the more he'll try to stall behind procedural hedges. Then ask tight questions pulled directly from the complaint's own brag pages. You allege a 100B brand. Please identify the valuation firm, date, method, and underlying cash flows. The immunity angle. Debunked. You'll hear a lot of noise about the Supreme Court giving Trump absolute immunity. That's wildly overstated. The court said presidents have criminal immunity for core official acts. Think, things only a president can do, and no immunity for unofficial conduct. Civilly, Clinton versus Jones is still the law. No immunity from private suits over private behavior. Discovery proceeds. Bottom line, you can't sue as a private citizen and then hide behind public office privileges when discovery gets spicy. Also, defamation law protects them, not him. New York Times versus Sullivan exists to guard robust debate about public officials. The irony of Trump using Sullivan's named defendant as a defamation piñata is chef's kiss. Legally, it's like trying to mug a judo instructor. The counter throws are built into the discipline.
So that means he's suing in his individual capacity. That means he doesn't have absolute immunity in this lawsuit. He can't claim that he has the presidential immunity powers. Now, he sues, look who he sues here, New York Times, Susan Craig, Ross Butner, because they wrote the book and the article that he claims is defamatory, where they write about John. And then he sues Peter Baker and Michael Schmidt for those articles saying, that the book Lucky Loser, the articles, the star-making machine that created Donald Trump, and then the other article for Trump, a lifetime of scandals, heads towards a moment of judgment. Okay, now, if I'm the New York Times, here's what I do immediately. I don't even think New York Times could file a motion to dismiss this lawsuit right away, and they could, and they'd probably win. Florida has robust anti-SLAPP protection, strategic lawsuits against public policy. In other words, trying to chill the First Amendment rights of a media company. Here, talking about, Donald Trump had multiple companies that went bankrupt over and over again, bankrupted casinos, bankrupted companies. He was found liable for fraud. He was convicted of felonies for business records cases. So to talk about a life of scandal feels, and again, if my opinion of it is that it feels like an accurate thing to say that he had a life filled with scandals. Talking about John Kelly warning about Trump becoming a dictator, especially what we see now. So to me, okay, what are the subjects of New York Times deposition and discovery? So if I'm New York Times, sorry, let me just go back to what I was saying. If I'm New York Times, take that discovery right now. You don't need to even do a motion to dismiss. Answer the lawsuit. Answer. Do a general denial. Then issue discovery to Donald Trump immediately. Set his deposition immediately. Everything is fair game now based on what Trump put in the lawsuit. All the Epstein stuff, because Donald Trump mentions Epstein, the birthday book, get him under oath immediately. You can now ask him as New York Times. If you're the New York Times, this should be a journalist's dream. You get to take Donald Trump's deposition, so take it. Set it. He has to be under oath. And what's he going to say? I'm the president. I'm not going to answer that question. You filed the lawsuit. So set that deposition. Ask him about the birthday book. Ask him about his policies right now. Ask him about the things that he's doing that show that he's behaving like a dictator right now. And when he goes, oh, I'm invoking executive privilege, go, sorry, you filed this lawsuit. We're entitled to ask you all of these questions right here. You don't have absolute immunity for us to, we get to ask discovery on these issues. And now, if you lie and you commit perjury, that could be a crime.
Per the AP, Trump also filed a separate defamation case against the Wall Street Journal over its reporting that he wrote a happy 50th note to Jeffrey Epstein, material Congress later released. He denies the signature. Congrats. You just made handwriting experts relevant, opened the door to subpoenas for calendars, guest logs, correspondence, and staff testimony, and guaranteed discovery skirmishes that revisit every factual line you don't want reread on primetime. That's not damage control. That's a Streisand encore. So does he have a case? Short answer, no, or at least nothing that survives first contact with actual malice doctrine and Florida's anti-SLAPP. The statements he targets are either A, true descriptions of published works and public records, B, opinions based on disclosed facts, or C, restatements of sources like John Kelly, whom the Times is allowed to quote. Public figure defamation is supposed to be hard. It's hard on purpose. So powerful people can't bankrupt journalists for doing journalism. Longer answer, even if he somehow survived early motions, discovery would be devastating to his own narrative. He's the one who made brand value, stock price, and reputation measurable issues. That invites math, not vibes. You don't beat the Times in court by yelling witch hunt. You beat them by walking into a conference room with audited numbers that say the opposite of what their reporting says. Good luck with that. Roast interlude. If your defense to lifetime of scandals is actually my brand is worth $100 billion, I regret to inform you that your lawyer has turned your crisis comms into Shark Tank fan fiction. What this means for the rest of us, this isn't just legal theater. It's a live test of whether anti-press, anti-truth tactics can bully watchdogs into silence. The Sullivan line of cases is on the ballot every time a powerful figure tries to make journalism unaffordable. Be very clear-eyed about the stakes. If this kind of suit succeeds, you get less information, they get fewer questions, and the next scandal never sees daylight. The flip side, if courts smack this down quickly and award fees under Florida's anti-SLAPP, it puts future bullies on notice. You can dunk on the media in rallies all day. Courtrooms still run on facts. Drop a comment. If you could put one document in front of Trump's lawyers at his deposition, what would it be? Tax returns, loan agreements, Truth Social investor decks, or something spicier? Tell me why. Share this video with that one friend who still thinks immunity means can't be deposed. Then ask them to name the case that says otherwise. Clinton v. Jones, you're welcome. Subscribe for courtroom-grade breakdowns with jokes sharp enough to cut a non-disclosure agreement. We'll cover every filing, every motion, and if it happens, the deposition highlights. Strongmen cosplay power. Real power is answering questions under oath. By suing, Trump just scheduled his own pop quiz, and the Times gets to write the questions. If he thought immunity would save him, he should have remembered the first rule of Litigation Club. Plaintiffs don't get shields. Plaintiffs brought the sword. If you're still here, you're my people. Hit like, hit sub, and light up the comments. We'll keep the receipts coming and the jokes legally actionable only in the court of good taste.
And remember, if you like what you see, hit that subscribe button.